Mr. McKinney, this attorney has recently been appointed to represent you, so they need to make sure they have discovery and everything. You understand?
Yes, I understand fully.
All right. Do you have any questions about anything?
If you would allow me, I'd like to bring to the court's attention my recent remagistration.
All right. That's something, because that's legal. That's something you'll need to speak to your attorney about.
No, I understood. It's just why I have the opportunity to establish a record, considering that he just got appointed at that time. Mr. Jimenez was my attorney. The magistration was held with me not having any counsel.
So let me explain something to you. And if I'm wrong on the law, I'm sure your attorney will correct me. But when you're magistrated, it's not an adversarial process. The only thing the magistrate judge is doing is telling you what your rights are and setting a bond.
From what I'm aware of, it's
All right, folks, we're heading straight into a Texas courtroom where things heat up quickly. Mr. McKenna, who just got a new lawyer, doesn't waste a second standing up for his rights. He makes it clear he wants it officially noted that his earlier hearing happened without an attorney, and he's now invoking his Sixth Amendment rights. He means business. The judge calmly responds, explaining that magistrate hearings aren't the kind where lawyers are required. But McKenna stands firm, saying he knows his rights and he's not backing down. He wants the court to hear him loud and clear. Stay with us. This case is far from finished.
Supreme Court ruling stating that you are allowed the assistance of counsel through all criminal proceedings.
Okay.
And in that particular matter, I was negated that right under the Sixth Amendment of the United States Constitution.
All
So
right.
I just like to get the court's record established with that.
No problem. We can put that on the record if you want to put that on the rerecord.
Yes, ma'am. I would love to. Please.
Sure. All right. Court is calling 2024 CR 009238, 2024 PF 16224, and 2024 PF 16225. State of Texas versus Raymond Lee McKinney. Can I have parties announced for the record for the state?
And fair settlement.
Defense.
Robert Maurer for defendant.
Are you Mr. McKinney?
Yes, I am, Ms. Boyd.
All right. Can you raise your right hand for me, please?
That'd be difficult. And
Well, no, because I need to swear you in.
okay,
You solemnly swear, affirm the testimony you give will be the truth and nothing but the truth. So help you God.
no disrespect to the court, Ms. Boyd.
Well, here's the thing.
I don't swear. That's what I'm trying to bring to
Right.
your attention. I don't
All
swear.
right. Let me ask you this. Do you affirm that you will tell the truth and nothing but the truth?
I guarantee to the court that I would definitely tell the truth, and I'm
All right.
aware of perjury.
All right.
And
You wanted
that
to place
I won't
something.
do.
You wanted to place something on the record?
Yes, ma'am.
You may proceed.
I'd like to place on the record that I was recently magistrated by Judge Ramirez.
Dive in. The court session officially begins, and several charges are brought against Mr. McKenna. As the hearing starts, everyone states their name for the record. Then, the judge tries to swear McKenna in, but he refuses. "I don't swear," he says directly. Instead, he promises to tell the truth. It's a strong move, and while the judge clearly isn't thrilled, she allows it. McKenna quickly circles. Back to his main concern, at his most recent magistrate hearing with Judge Ramirez, he didn't have a lawyer present. He says this violated his constitutional rights, and now that claim is officially part of the court record.
It was this past Thursday or Friday, if I'm not mistaken, and I was without counsel. And from my understanding, the Sixth Amendment grants you the right in all criminal proceedings to be able to have this assistance of counsel, which I didn't have during that remagistration. During my first magistration, counsel was provided through the public defender's office, and that was negated in this recent remagistration. So I want to just make sure that it was brought to the court's attention and the record was established with that, so there could be an objection that the court was notified of in that regard.
All right. You said something interesting. You said that the public defender's office was present?
In the first, and that was June 14th
Okay.
of this year.
All right. Defense, is there anything you wish to add?
No, Judge.
All right. Thank you for letting me know.
Yes, ma'am. Thank
And
you.
there's a record and it's been preserved. Okay.
Yes, ma'am.
All right. Thank you.
Yes, ma'am.
Thank you, Judge. I'll see you on the 7th.
All right. Thank you.
Stay with us. Things are getting more intense. McKenna tells the court that during a previous hearing, he did have a public defender, but this time, no one showed up for him. He's arguing that the process isn't being handled fairly. The judge checks the date. June 14th, and confirms it on record. The defense team, however, stays quiet. The court accepts McKenna's statement and makes sure it's officially recorded. The tension in the room is thick. McKenna isn't looking for pity. He just wants the system to acknowledge what he's saying. The court hears him, but it's not giving an inch.
Let me explain something to you. I don't know what your issue with your attorney is, but I'm going to tell you what I've told every person who's been before me, right?
Yes, ma'am.
I've been a defense attorney. I've been a prosecutor.
Yes, ma'am.
Now, I run my court a certain way because when I was a defense attorney and a prosecutor, you pick up things from other judges, and then you decide what you feel would work and what you would have liked if you were a defense attorney or prosecutor.
Yes, ma'am.
So in this court, I require that I make sure that everybody have all their discovery. Of course, we're not going to be up in here a year waiting for discovery, right?
Yes, ma'am.
Then the other thing I require that attorneys receive offers from the state.
Right.
And when your attorney receives an offer, ethically, they're obligated to give that to you. Now, you may think that offer is ridiculous, right? But I tell people, let's not say those words because then people get here. And I want everybody to be at this level when they negotiate. So if your attorney gives you an offer, that's the offer the state has made.
Get ready. Judge Boyd steps in and takes charge. She speaks with confidence and makes it clear she knows both sides of the courtroom, having worked as both a defense attorney and a prosecutor. She runs things with strict order and doesn't waste time. She says the discovery process will move quickly. This won't drag on for months. The state will make its offers, and defense lawyers must share them with their clients. No exceptions. Even if someone thinks the offer isn't fair, it still gets delivered. That's how it works. This is about facts and fairness, not personal opinions. McKenna's realizing fast. This judge means business.
Defense attorneys, this is what people think. Defendants believe sometimes that defense attorneys can control what offer the state is going to make. They really can't. All they can do is they could present maybe mitigation to the state and say, hey, this is why you should consider giving this person probation. Or either they can present something to them and say, this is why this case should be dismissed.
Yes, ma'am.
And then you know what the state will do? In this court, I will tell you, the state will consider the argument that the defense is making.
Yes, ma'am.
And you know what they could say? You know what? You're right. We're going to dismiss it. Or you know what? You're right. The offer that we're making is too much.
Yes,
That's what they may say.
Yes, ma'am.
Or they may say, no, this is the only offer we're making. And then once your attorney presents that offer to you, you have one or two choices. You can say, I'll accept it. Or you can say, I won't accept that, but let me make a counter offer. Tell the state I'm willing to accept A, B, and C. And then your attorney will let the state know he won't accept that, but here's a counter offer for you. And then guess what? The state can say, oh.
Here's the truth. Many defendants think lawyers can control the outcome or force a better deal. They can't. All an attorney can do is present the facts, ask for leniency, or argue for the case to be dropped. That's it. After that, it's up to the state. They can accept, reject, or make a counteroffer. Simple as that. The judge breaks it down clearly, like a commander giving clear instructions. You get the offer, respond, then either go to trial or take the deal. For McKenna, the options are shrinking. The process is firm, exact, and unshakable. It's the legal system in full motion.
Let's consider that. And they can say, yeah, we'll accept this counteroffer. They can say, no, the only thing we're offering is A. And then your attorney will bring that back to you. And then now you have a choice. Either you're accepting what the state's offer or either you want a jury trial. That's the thing. Now, I can tell you, some attorneys have great bedside manners. What do I mean by that? They sit with you, they hold your hand, they talk to you about how your day is going, how's your family doing. There are some attorneys, they're not into that. They're like, I'm here about this specific case. These are the elements the state needs to prove. These are the facts I have. And this is police report. Let me defend you. So that's where we are.
Yes, ma'am.
So what is your issue?
My issue is Mr. McCray would not let me get one word in. Judge Boyd, I wanted to at least speak my testimony.
All right, so let me talk to you about speaking your testimony. if you're speaking of your testimony as something that you want to present to me,
Now things really start to heat up. The judge talks about defense attorneys. Some are more approachable, others more reserved, but all of them are there to focus on the case, not emotions. She makes it clear this courtroom isn't for therapy, it's for getting things done. McKenna tries to speak up and share his side, but the judge cuts him off fast. She tells him plainly, "You only testify at trial." This isn't story time, she says. This is about following legal procedure. If he talks now, his words could be used against him later. McKenna is clearly frustrated, but the judge doesn't flinch. The law is the law, and she's sticking to it.
the only time you're allowed to present that to me is if you decide to testify. And I'm sure your attorney has told you that's completely up to you, whether you testify or not.
Yes, ma'am.
And I'm sure Mr. McCray has probably told you the good things and the bad things if you decided you wanted to testify. Right? As far as speaking to me and saying, oh, my case should be dismissed, and here are the facts that I want to tell you, this is not the part of the process where I received that information. The part of the process where I received that information is if you have some kind of mitigation. For example, if you say, yeah, I could hypothetically, yeah, I committed a theft, but let me tell you why I committed that theft. I'm starving or something of that nature. I'm trying to feed my children. Doesn't mean that you didn't do it. It just means that you're trying to say, Judge, go a little light on me because let me just tell you about my life. All right?
Yes, ma'am.
So
Yes, ma'am.
that's the only time. So for you to be telling me what you think the facts of your case are, guess what? If you want to tell me stuff right now, anything that you say can be used against you at jury trial. That's where this ends up. So sometimes attorneys are trying to protect clients from themselves. I've had plenty of clients where I've had to protect them from themselves. And then some of them like, you know what? I'm still going to do my own thing. And I'm like, an explosion is going to occur and you're going to get the blowback from
Pay
it.
close attention. This part's important. The judge gives a tough but honest warning. If you speak out now, you might hurt your own case. She's seen it before. People ruin their chances just because they couldn't stay quiet. I'm trying to protect you from yourself, she tells McKenna, but he's emotional and pushes back. This is my life, my moment, my fight, he says. The judge doesn't dismiss him. She agrees that every case matters. But she reminds him, this is criminal court. The outcome is serious, either probation or prison. No in between. It's tough. It's real. And the pressure doesn't let up.
So you understand?
I do now. Yes, ma'am.
All right. See, sometimes we just need to,
I just need to talk. I'm sorry. This is my life and it's a very important day. I'm sorry.
no, here's the thing. Every single case is extremely important. People tell me sometimes I take too long on cases, but you know what I tell them? The person who's standing before me, this is extremely important to them because it's their life. This is a criminal court. You're looking at probation or you're looking at prison time. You understand?
Yes.
So that's where we are.
Yes, ma'am.
So is there any other issues with Mr. McCray? So then the next thing I need to discover from both parties is where are we on discovery? This is where I'm trying to figure out if your attorney has received everything from the state that he needs to adequately and professionally represent you, okay? All right, so is there any outstanding discovery that you know of, Mr. McCray?
Not that I'm aware of.
All right, have you been, lately there's been an issue with downloads. Have you been able to download everything?
Yes, sir.
All right. State, were you able to tender an offer?
I said her today, I only offer.
Okay, so here's the thing. The state has tendered an offer to you. I'm going to have you sit in the box and internalize it because the state is saying that offer is for today. That's it. So I'm going to give you a chance to discuss that with your attorney. And if you decide you don't want to accept it, then we'll move towards a jury trial. Okay.
Okay.
All right. Thank you.
Thank you, ma'am.
You're welcome.
Coolin' now. The clock is ticking. The court moves forward quickly, checking on where things stand with McKenna's lawyer and the case file. Both sides confirm. Discovery is almost done. The state has put an offer on the table, but there's a catch. It expires today. No do-overs. This is McKenna's turning point. The judge tells him plainly, sit down with your lawyer, make a choice, accept the deal or reject it. But if you pass, we're going to trial. From here on out, every decision matters. This courtroom is no longer just a place, it's a battleground. And now, it's McKenna's move.